In May this year, the federal government handed down a budget that had estate planning lawyers like myself fielding phone calls for weeks. The headline was a new 30% minimum tax on discretionary trusts. And buried in the fine print was a line that suggested testamentary trusts, the trusts we build into our wills and specifically to protect your children's inheritance, might get caught up in this new tax as well. 5 weeks later, the government appeared to walk a lot of that back. Good news, right? Except the story didn't quite end there. Just a few weeks after that, fresh concerns emerged from people who read the fine print for a living. That some of these families who are supposed to be protected might not be protected after all. This is genuinely one of the more fluid areas of tax law I've been tracking for a long time. So today, instead of giving you a tidy answer with a bow tied up, I'm going to walk you through exactly how this is unfolding, because understanding the shape of uncertainty is more useful to you right now than any false sense of certainty around what's to come. I'm Sue Ellison-Whyte, and this is the Unsolicitor's Opinion. So let's get into it. Welcome back to the Unsolicitor's Opinion, the podcast where I take you through what's actually happening in the law and tell you what it means in plain English without the jargon. Quick reminder before we start, everything in this episode is general legal education only, not advice for your specific circumstances. And this topic, more than most that I've covered on this show, is a genuine moving target. So I'm going to be really precise about dates, very honest about what's confirmed versus what's still being decided. So let's get into it. On the 12th of May 2026, as part of the federal budget, the government announced it will introduce a new 30% minimum tax on discretionary trusts, starting from the 1st of July 2028. To understand why that mattered so much, you need to understand how trusts are normally taxed. Right now, a discretionary trust is what's called a flow-through vehicle. The trust itself doesn't really pay tax. The income flows through to whoever it's distributed to, and it's taxed in their hands at their own personal tax rate. That's exactly how a testamentary trust, a trust which is set up in your will, has always worked as well. And it's precisely why testamentary trusts have been such a powerful estate planning tool. If you leave money to your minor grandchildren through a testamentary trust, that income can be taxed at ordinary adult rates, including the tax-free threshold, instead of the punitive rates that normally apply to a child receiving investment income directly. That concession sits in Section 102 AG of the tax legislation, and it's one of the main reasons families use these structures. So why did the alarm bells go off when the budget's original proposal that 30% minimum tax was going to apply to discretionary trusts broadly? The initial carve-out for testamentary trusts seemed to be really narrow. Only trusts that existed at the time of the announcement, 12 May 2026, were clearly protected. Anyone setting up a new testamentary trust after that date, including through your will, which simply hasn't been triggered yet because it's triggered upon death, was on the face of it going to be caught. For a solo practice like mine, working with families across the Mornington Peninsula who are actively updating their wills right now, that presents a real problem. It means that the advice I'm giving someone drafting a will in June could become outdated the moment they actually need to rely on it. There's a genuine, well-founded concern in the profession that this would undermine one of the few tools we have to protect vulnerable beneficiaries: a minor child, a grandchild with a disability, or someone who simply isn't ready to manage a large inheritance. Within about 5 weeks of the original announcement, the government shifted their position. On the 18th of June 2026, the Prime Minister and Treasurer issued a joint statement announcing that discretionary testamentary trusts, not just the ones that already existed on the budget night, would be excluded from the 30% minimum tax, provided the trust established for what is described as a genuine testamentary purpose. That's a real broadening to their original proposal. It's no longer just about protecting trusts that are already up and running. New testamentary trusts, the ones that are created under wills, people are writing today, for deaths that haven't happened yet, were now being brought into the exemption as well. But there were conditions attached to that. Because it's not a blanket exemption, and the details actually really matter in this case, 2 conditions were confirmed alongside the broadening. Number 1, the exemption is limited to income from assets of the actual deceased estate. It's there to protect a testamentary trust doing what it's meant to do, holding and distributing what someone has left behind, and not allowing people or beneficiaries to inject unrelated money into the testamentary trust after the fact simply to access a lower tax rate. Number 2, for testamentary trusts established on or after July 2028, when the new regime has started, the exemption only applies if the trust can benefit individuals and income tax related exempt entities. In plain English, if your testamentary trust distributes to a company as a beneficiary, the kind of bucket company arrangement some families use, that structure won't qualify for concessions moving forward. What stayed constant throughout, however, is income relating to vulnerable minors was proposed to keep receiving concessional treatment broadly, consistent with today's rules, and fixed trusts, complying superannuation funds, special disability trusts, charitable trusts, and deceased estates themselves were never meant to be the target of this measure in the first place. Also, they say. On the 8th of July, the Treasury released a formal consultation paper setting out the detailed design of how all this should work in practice. Submissions closed on the 31st of July. At that point, this was still a consultation paper and not exposure draft legislation, and certainly not law. Here's where I have to be really honest with you. Because this is exactly the kind of moment where it would be easy to give you a neat, reassuring ending, and it wouldn't be responsible of me to do that. In early August 2026, in the days immediately after that consultation period closed, further material on this measure emerged from the Treasury, and it prompted a genuinely concerning public response from at least one well-respected private client lawyer, writing in Industry Trade Press. His warning in short: some of the drafting appears broad enough that it could capture arrangements nobody intended to target. He specifically flagged 3 groups: surviving spouses who inherit indirectly through a testamentary structure rather than by a direct transfer, post-death testamentary trusts set up after a parent dies, suddenly leaving young children, and child maintenance trusts that arise out of family law property settlements after a relationship breakdown. This professional's concern was that on one reading, these could be exposed to the minimum tax in ways that undercut the very protection the Treasury's June announcements seem to be promising to the public. What I want you to take from this, and what I don't. I want to be really careful about how I frame this for you. This is one experienced practitioner's public critique of the Treasury material. It isn't a change in the government's policy, and it's not the final word on the matter. The government has stated its position as of the June announcement, and it remains that testamentary trusts are meant to be protected. But it is a credible, specific and public concern raised by someone whose job is reading exactly this kind of draft for a living. And it tells you something important. As at the time of this recording, the fine detail of how testamentary trusts will actually be treated is not settled. The broad policy intention announced in June has not, as far as I can confirm, been translated into final legislation that puts these concerns to rest. So if you've heard the June announcement described elsewhere as the end of the story, quite frankly, it isn't. Treat anyone, including me, on earlier draft of this very episode with appropriate scepticism if they tell you that this issue is fully resolved, because it's not. This segment is based on trade press reporting as current on the 19th of August 2026. So what I'm trying to put out there is effectively this is subject to change, and all we can say is that nothing is set in stone at this date, other than intentions have been publicly expressed by the government, but the legislation hasn't yet been finalised. So if you've already got a testamentary trust with trust provisions in your will, the overall direction of travel, the June announcement, the government's stated intent is somewhat reassuring. But given what we've just uncovered, I wouldn't describe your position as settled just yet. This is precisely the environment where a periodic will review earns its keep. Not because I think this measure is designed to catch ordinary families, but because the gap between the stated policy and the final drafting is exactly where problems like the ones raised in August tend to hide. If you don't have a testamentary trust yet, or if you've been weighing up whether to add a testamentary trust to your will, I don't think this saga is any reason to abandon the idea necessarily. Testamentary trusts remain a legitimate, long-standing, and based on everything said publicly so far, a protected tool for looking after vulnerable beneficiaries in your life. What it is a real reason for is to have that conversation with proper current advice rather than relying on something you read months ago, including in the future this podcast. The cost of doing nothing is rarely zero. A straightforward inheritance paid directly to your child offers no protection at all if their relationship breaks down, if they get sued, if they go bankrupt, or if they simply aren't ready to manage a large sum of money in their life, regardless of how this tax question ultimately resolves. The honest bottom line, I try not to give you false certainty on this show, and I'm not going to start on this topic. What I can tell you honestly is this: the direction of the government policy has consistently been to protect genuine testamentary trusts. Even after 2 rounds of walking things back and clarifying, what I can't tell you yet is whether the final legislation will actually deliver that protection cleanly, particularly for less straightforward situations like blended families, a sudden parental death, or a family law settlement. So to bring it all together, in May, the budget put testamentary trusts on notice. In June, the government walked a lot of that back and broadened the protection. And in August, real credible questions emerged about whether the fine print actually delivers on the promise for everyday families that it's meant to be protecting. None of this is settled. It's proposed law, it's still being drafted, still being fought over by people who do this for a living. If a testamentary trust is something you're considering, or if you already have one and you're not sure how these changes are going to affect you, that's exactly the kind of conversation that is worth having properly, with your actual will and your actual family circumstances on the table, and with advice that's current, not advice from a few months ago. You can book a conversation with our staff at Ellison-Whyte.com.au. Next episode, we're going to be looking into something just as timely for families on the Mornington Peninsula. With the great wealth transfer, what we're seeing a lot of is private lending between parents and adult children, and why an informal arrangement with your own child can be the most expensive documents you never signed. I'm Sue Ellison-Whyte. This has been The Unsolicitor's Opinion, and I'll see you next time.